SJC-11071.
Good morning. If it
Oh,
please-
hold on, please.
Oh, sorry.
Okay, let's proceed. Yes, ma'am.
Good morning. If it pleases the court, Barbara Cabin on behalf of the juvenile. Here, there is no dispute that the juvenile and his mother were non-English speaking individuals who were entitled to the assistance of an interpreter as a matter of right. That did not occur in this case.
How many years ago was this now?
This was a 1995 plea.
So that's 17 years?
That is correct.
You say they were not provided it? I thought the judge concluded that they were.
Well, what the judge concluded was that an interpreter had been ordered. There was nothing in the official record of the case to support the determination that, in fact, an interpreter was present. And, in fact, the juvenile provided credible and reliable information to support the juvenile's assertion and his mother's assertion that, in fact, no interpreter was present.
And what is
The billing records, was that the billing
It was
records?
more than the billing records, Your Honor. That was one critical factor. The billing records that Justice Botsford refers to was provided by the Committee for Public Counsel Services Chief Financial Officer. He asserted that he still had his records from 1995, that he was able to search those records, and that the standard in 1995 was that the interpreters provided bills to CPCS for reimbursement. And when he searched his records, there was absolutely no bill from any interpreter for any proceeding in this case against
Nor was
the
there a
juvenile.
bill from the lawyer either.
There was not.
And I take it the practice was to get a bill from the lawyer as well. So there was no payment in this case at all.
And one would hope that that's not atypical, but given the ineffective assistance of counsel that occurred in this case, where all the attorney did was represent the child at arraignment and then 10 weeks later plead him out, it raises some questions.
But how do we know that? First of all, this is 15 years ago. The lawyer has no memory of this case, not surprisingly. How do we know that's the only thing that happened?
Well, when we look at the docket entry, what we know is that the attorney filed absolutely no motions on behalf of this juvenile. Theoretically, at least that would have been
Very extensive police report documenting the underlying offenses, both with the victim, with the victim's family, and with others. I mean, it's not like somehow there was no evidence in this case.
That's not sufficient evidence, as the bench well knows. I mean, this is a case where the child wasn't in custody. There was absolutely no reason to rush to resolve this case. You know, when a kid is detained, frequently attorneys will say the kid is doing what the kids call dead time. They're sitting in the Department of Youth Services, so let's resolve the case. In fact, in this case, there were multiple issues that should have been addressed.
But this is very speculative, 15 years after the fact.
It is, but when we look at the information provided by neutral resources, such as the SJC's Commission on the Study, I want to get the title right, the SJC's Commission to Study Racial and Ethnic Bias in the Courts, that issued a report in September of 1994. The report was entitled Equal Justice, Eliminating the Barriers. This information was presented at the trial court in the motion for a new trial. And in that report, the commission stated, contrary to Massachusetts law, this is in 1994, legal proceedings are held without interpreters, with unqualified and uncertified interpreters on a regular basis in Massachusetts.
But how do you know that happened here? Everywhere, all over these documents are court interpreter requested, Cambodian interpreter requested, phone conference with interpreter to confirm and I mean, there's nothing here to suggest that a Cambodian interpreter was not requested and present, except nothing.
There's nothing here to actually support the inference that one was present. And if we look at the 2001 report by the National Center for State Courts entitled Operational Review of the Provision of Court Interpreter Services in the Courts of Massachusetts, and that was, again, a neutral body, they determined as late as October of 2000, there were only 3 certified Cambodian interpreters for the 120 courts in the Commonwealth.
Well, do you agree that interpreters were requested? I'm not saying that. So you
Yes.
consistently.
Absolutely. But what we have is a situation where that should not be sufficient when we're talking about the waiver of constitutional rights by a child.
It shouldn't be sufficient if this motion were brought a few years later, but 15 years later, when all the underlying records have been destroyed, that makes it impossible to sort out. And whose burden is it to sort it out at this point?
What other records would there be? You might have the memory of the judge. I'm not sure there would be other records.
A recording. would be a recording of the proceeding, one would presume.
One would presume,
1995.
but if you look at so many of our cases, those recordings, Gautreaux occurred, it was a 2003 plea, and by 2008, the recording was gone.
Right. You would think that if I don't speak English and have somehow not had any idea what was going on, that at some point, other than 15 years later, I might say, oh, by the way, I didn't understand what was going on back then. This person had a lawyer.
This person had a lawyer, and a very important part of the claim here is ineffective assistance of counsel. But more than that,
For
we're
what, for
talking
not securing an interpreter?
for not doing anything, for not looking.
Know of, because of course she hasn't any memory or records because this was 15 years ago.
But the docket is insufficient, and that under Boykin is not enough. Boykin basically says we have to create a record that is capable of review at any time that review may be sought after the fact. And here we're talking about a juvenile, and the presumption that a juvenile, an immigrant child from Cambodia, whose mother did not read, speak, or understand English, would know that he even had a right of appeal or that somebody should revisit this issue it's just hard to imagine. And the fact of the matter is that this court has on many occasions provided special status to juveniles.
So what has caused this issue to arise now? Why 15 years later?
Okay, the case was brought to me when this young man basically was doing some work with youth in the community, and he basically immediately disclosed that he was on the sex offender registry. The people who he was working with at that time brought the case to me and said, this makes no sense. He's not, it's not somebody we think of as a sex offender. He works really well. I said, let me run his record. I said, well, the only sex offense he has was when he was 13. How did that happen? And then I began the
Have
investigation.
subsequent offenses?
Yes.
Isn't there
Different kinds of offenses?
Yes.
Property, violence, what?
A whole host of things.
I thought there's a reference in the Commonwealth's brief that he is facing a charge of second offense failure to register. Is that right?
That is true. That is pending now, and that has been stayed since 2009 when we brought the motion for a new trial. So yes, there is a collateral consequence involved here, if that is the gist of the question. But that was not the impetus for bringing this case. The impetus for bringing this case was the fact that, once again, we have a child who did not make a knowing and voluntary waiver of his constitutional rights, and pursuant to Chapter 119, Section 55, and in cases like Commonwealth versus a juvenile and Alfonso A., where we've repeatedly recognized that children should be entitled to special protected status, this was another case, to me, where, in fact, that did not occur.
But what do we do here? We have the judge who was the judge at the time of the plea, correct? Who says, my practice was that when an interpreter is ordered, it's reflected in the docket, and if the interpreter does not appear, the case is continued, and that there would not be any documentation that the interpreter was present. And that, combined with my practice that I would not proceed without an interpreter, I conclude that he had an interpreter. I mean, isn't basically that what the judge found? Perhaps not elegantly, but isn't that the gist of what the judge found?
What the judge really stated was that, in fact, an interpreter was ordered. She did not say that she had any recollection of this case. She did not say that she reviewed any of her notes from this case. And she did not say that if an interpreter was not present, I would not have gone forward. What she repeatedly said was an interpreter was ordered.
Right,
and then she went on to...
But she said if it was not, the case would be continued, which implies that...
But basically, what she also basically said was, I understand that if there was no interpreter, the plea wouldn't have been voluntary, but an interpreter was ordered. And basically, all the cases when we talk about a judge relying on his general practice, there has been more than just that blanket statement of general practice. If you look at Gautreaux, what we had in Gautreaux was not just general practice, but we had a statement by the clerks in that courthouse that there were routinely 2 Spanish-speaking interpreters present in that court to basically step up and provide assistance at any time. We also had in Gautreaux further facts that, in fact, the whole issue of language had been litigated, and although the judge indicated in that case that he didn't quite recall whether or not there was an interpreter present. He knew that that issue of language had been litigated and he would not have gone forward. We have none of those supporting documentations in this case. And to further distinguish this case from Pagaro, from Gautreaux, and all the other cases, in this case, there is substantial, objective, reliable evidence from sources other than the affidavit of the individual involved that raised substantial doubt. And as this court said in Goodrow, basically 442 Mass 341 at 348 in 2004, the defendant's submissions do not have to prove the factual premise, but must contain sufficient credible information to cast doubt on the issue. And once that doubt is cast on this issue, the burden should have gone back to the Commonwealth to prove that, in fact, this proceeding was not infected with prejudicial constitutional error.
This record is very strong. I mean, on September 19th of 1995, an interpreter was ordered for the October 17th proceeding. October 17th proceeding, he tendered his plea. The sentencing was continued to November 21st, and it says, and an interpreter then was ordered for November. Why would they be ordering an interpreter for the sentencing on October 17th if they haven't had an interpreter for the change of plea? It makes no sense at all.
All that we have throughout this whole record is this constant saying an interpreter's ordered, an interpreter's ordered. I think that you basically say, the bench said in Gautreaux that, in fact, this entry of just an interpreter ordered is not really sufficient and they need to improve their practice. Well, this is a perfect example of why that's not sufficient. In many cases, and in fact of all, Pangaro, Lopez, the tapes are gone, and all we have to rely on are the dockets. And these dockets are just not sufficient. The fact that an interpreter is ordered doesn't answer the question of whether an interpreter was there. And if there was no interpreter there, this juvenile did not have the assistance, the guidance, the advice of an informed parent. In Chapter 119, Section 55, we don't even want a kid to be arraigned without a parent present. And if there's no parent there, we, in fact, will appoint a guard, the court will appoint a guardian ad litem, because we know children need the advice and guidance of a parent, a competent parent. In this case, where we have all of this credible and reliable information that there were only 3 certified Cambodian interpreters for the whole Commonwealth, it doesn't stress credulity to basically think, did they send one of those scarce resources way out to Northampton for a delinquency proceeding, in contrast to keeping them in Lynn and Lowell, where we had large Cambodian populations? We were under-resourced, and the fact of the matter is, just the fact that there's an order doesn't mean the interpreter was there.
Then you would probably take the position it's likely they never sent an interpreter, Cambodian interpreter, all the way out to Northampton, since they only have 3. That'd be your position.
I wouldn't go that far because I can't basically say that. Maybe if it was a Superior Court case or an adult case that was very important, they might have. I'm not saying that. But I'm saying that in general, there is a sense that juvenile proceedings are less important. We have the statement to me by trial counsel, and I understand that it's my statement of what she said to me. But basically, she said to me, in those days, we frequently proceeded without an interpreter, and we'd have the juvenile interpret for the parent. I've heard that from other attorneys. I wasn't practicing in 1995, but I've heard that from other attorneys. It wasn't uncommon in those days. She also went on to say, well, we seal juvenile records anyway, so basically the implication being, what's the big deal? We know that's incorrect. There tends to be, particularly in the 90s, more, I guess I'll just say it bluntly, sloppiness about juvenile proceedings. And we would hope that wouldn't occur. But that is why the docket is so important. In this case, we don't have anything of the file. The whole file was lost. Not only did I have the trial court look for it, I had the archivist for all the files look for it. No place could we turn up this file. We have no idea whether there was a signed waiver of jury trial. All we have is a stamped entry, a pro forma stamped entry that has, with a line that says, jury waive, and then there's a line where theoretically you would expect someone to initial it or something like that. That's totally blank. We have nothing in this docket that tells us that, in fact, the child knowingly and voluntarily waived his right to trial, that he basically understood that the facts of the case were read into the record, the police report, that he admitted to the facts of the case. There's nothing in this record, there is nothing in this docket to support the determination that, in fact, this child made a knowing and voluntary
Was the
waiver.
file destroyed or misplaced, or?
We could never find
We
it
don't- we
anyplace.
just don't know.
We just don't know. I really went through every possible trail I could to try to turn up this file because we had so little information. There was nothing there anyplace.
Thank you, Counsel.
Thank you.
Good morning, Your Honor. Stephen Greenbaum for the Commonwealth. The two problems facing the juvenile here is the presumption of regularity and a burden that he couldn't overcome given the substantial deference we usually give to motion
Yeah,
judges.
let me ask you about that. Tell me how we should analyze this. We have the judge's findings that the presumption was not overcome. What, that is reviewed as clearly erroneous standard
It says
or abuse of discretion standard?
case law abusive it's I tried to find that myself. There's substantial. I believe it's something like clearly erroneous, or if there was a manifest injustice. Some of the cases say. I think that's the standard, but I think it boils down to, given the case law that says that we respect given the substantial deference, you've got to find that the judge was clearly erroneous in finding that she wasn't convinced. And I think the judge here, it wasn't the matter, I think the judge here made a factual finding that my docket, the way I practiced then and now, reflects that an interpreter was there.
How does it reflect it?
By virtue of what she said her practice was. If it says interpreter ordered for a certain date and the event went on that date, that means the interpreter was there. That's what happened here. Therefore, according...
And does she say it would be continued if the interpreter weren't there? Or is that
I forget that precise language, but at some point later on, she says, either way, an interpreter was present. It's cited in my brief. In a certain page, she specifically finds either way an interpreter was present. She looked at I think she was trying to be sensitive to the juvenile's position and the juvenile's affidavits, and the juvenile and his mother said there was someone there translating for the victim's family, and she said, well, if I've even credited that claim that someone was there interpreting, it wouldn't have been just for the victim's family. There would have been an interpreter here for the defendant. So she said, either way, whether I rely on my interpretation factually of what the docket meant or your claim that someone was there, there was an interpreter present.
Are you focusing a whole lot or relying a whole lot on the docket entry, which is interpreter ordered? I have some memory
this is
of
what the judge was
those
relying
days. Judges were trying very hard to do a good job in routinely ordering, but that was about, in those days, in the 90s, that's about as often as far as it got, at least in some courts, including the probate and family court. You could order till the cows came home, but that doesn't mean that someone was available. Mostly they weren't.
I would
So
say
what
not
can it
according
tell
to
you?
the judge here. It's not the judge here. Her statements in the motion hearing, in the first hearing, were as to her practice. Now,
It's more equivocal than
we
that.
might find otherwise, but I believe she stated that that's the way we docketed things.
And you're getting that from her the transcript.
From the there were no written findings. It
And-
would be
Can you tell me again that page? I think
that
it's
particular. Start looking at page 11.
Yeah. I have 5.
Because we always docketed that if an interpreter didn't appear, it was continued for that reason. She specifically states that on page 11 of the initial motion hearing. There was a motion to reconsider. But it's page 11 of the first motion hearing.
If I can go back to the presumption of regularity. So we look at whether the presumption has been overcome. And if the presumption is overcome, does that mean that the defendant wins, or simply that the judge then holds an evidentiary hearing?
It means the judge holds, it typically, as far as I can see, it means the judge holds an evidentiary hearing. I imagine there could be circumstances where the judge could do otherwise and grant the motion, but typically the case law says then the defendant is entitled to an evidentiary hearing.
So am I correct then that our analysis should be, was the judge in her findings clearly erroneous in making findings that the presumption had not been overcome and not holding an evidentiary hearing?
You could. Here's another twist in this case. The defendant specifically, Commonwealth's position was, if you were inclined to grant this motion, you must hold an evidentiary hearing. And at the first hearing, the juvenile specifically said, I don't think it's necessary to hold an evidentiary hearing. So that we're in a position the juvenile did not request and specifically did not ask for an evidentiary hearing. So the judge was asked to rule on the papers and denied on that basis. Were this, I'm not suggesting that you should, but were this court inclined to come to a decision that an evidentiary hearing should have been and perhaps should now be granted, I would like to point out off the record, as far as I know, the judge who heard this motion and was still sitting on the bench when this was in the appeals court has now retired. And we create, I can't tell you what it is we'll create a whole new set of issues. We'll probably be back here on that, but that's true.
But,
would like, oh, sorry.
But in terms of what a judge
Right,
generally
the judge would
does,
have to have an evidentiary hearing.
the
None of
judge's
these
first decision
affidavits-
is the evidence strong enough to warrant an evidentiary hearing?
Yes,
Which is lower than is it strong enough that the defendant wins?
I agree. I would want to come, the issue about the accounting and the CPCS accounting, all that was addressed, and this was in a motion to reconsider, and there was an affidavit that supposedly the billing showed no bill from the lawyer or the interpreter. And the judge basically looked at it and said, well, wait a minute, this doesn't show me much. It wasn't raised below, and I happened to look at the Chief Justice's treatise on juvenile law, and I'm not sure what the practice was back in 1995, but this was a court proceeding, and I'm not sure that court-ordered interpreters were paid out of the CPCS budget back then or ever if they're not paid out of the trial court budget, so that, well, it wasn't explored below. If this is a further reason to indicate why that
At
affidavit...
that point, I thought the CFO or whatever it was from CPCS said that yes, they did pay for the interpreters.
The affidavit from, I believe, from the CPCS officer said, we paid for interpreter services. He didn't necessarily say he paid for court-ordered interpreter services. CPCS defense counsel sometimes need interpreters to meet with their clients. So there's another, in terms of whether or not that document by itself was sufficiently reliable, and I don't think the judge abused her discretion in finding it wasn't.
Do we know
There's further reason.
Do we know that back in that particular time span, whether some interpreters were salaried because the demand for that particular language was so high, and some others might have been paid by contract, by the hour?
I know you might find this hard to believe, but that was before my time working in the criminal system, so I can't answer that question.
I would think that if it were, it would not include Khmer, the Cambodian interpreters, being on salary, but I don't know.
Yeah, I can't speak to the practices of the juvenile court back then, or really to them now, to fill in those blanks.
What consequence, or what do we do with the fact that this juvenile spoke some English, apparently? Apparently he was in the schools, could arguably have proceeded without an interpreter, even though all agree here that he should have received one. I mean, does that strengthen the juvenile's hand to say, it's not impossible that a plea could have been done with the juvenile's command of English, because the juvenile had been in this country for a long time, been in school. I gather from the record, the discussion with the tutor, or whatever that person was in English. Is that?
It appears to be the discussion with either the caseworker or the tutor appears to be in English. There's nothing, those educational documents don't indicate that the juvenile had difficulty speaking or understanding English, just that he had difficulty reading and with a lot of academic skills.
Now, would that?
But I could be, I mean, if we want to speculate as to what could have happened, yes, well, the fact that he spoke and understood English could perhaps indicate they went without him, but that's not what the judge found. I mean, we can speculate forever, but I think the judge here specifically found, look, this docket, I know how I ran my courtroom, I've been doing it for 16 years. This docket indicates to me there was an interpreter present.
All it says is that we always docket it if an interpreter didn't appear and it was continued for that reason. It doesn't say, you know, if I have a child, a juvenile who speaks some English and a mother who doesn't, then I always waited for an interpreter, and if I didn't have an interpreter, then we would never go forward. unless somebody brought it to her attention, she'd be standing there with a mother standing there silent with a juvenile who speaks some English in a docket that says it's been ordered because somebody put that on there, and now she has a continuance or not. But she only says, if we did it because an interpreter wasn't there, we would put on the docket it's because we didn't have an interpreter.
Granted,
Anything about her practice with respect to.
granted that perhaps that was a possibility, and the judge's certainty about the presence of an interpreter was perhaps not 100%.
No certainty
What
about
would
the
she have
presence
done?
of an interpreter
I suppose
in
what
this
went to the
transcript.
judges, what would an evidentiary hearing have? What would have occurred in an evidentiary hearing on the defendant and his? I mean, basically a repetition of the testimony in the affidavits that she didn't credit. I think that's what we have to think too. If a judge is going to grant an evidentiary hearing, well, in order to hear what? I mean, I'm not sure. At least based upon the affidavits that in crucial parts which she didn't credit, the CPCS document which had some holes in it, and some educational assessments. I don't believe when you look at that overall you can find an abuse of discretion in not going forward with an evidentiary hearing.
You're asking us to go a little further than we've been willing to go in this kind of case, and with respect to whether immigration consequences have been rendered in the kind of affidavit that we thought was appropriate from a judge in those circumstances. You could arguably come to the conclusion that what you've pulled out of this transcript really isn't there, and therefore it is inadequate to support the presumption of regularity in this case.
Again, that's this court's decision. Our argument, obviously, is that there was. This case doesn't seem to me that far removed from Pingaro and all these other cases where there's a clearly collateral consequence motivating a motion being brought at a late date. Yes, and I understand all the studies that show, and yes, there's all this peripheral evidence that indicates there were problems with interpreters back then. But if that's the case here, then virtually every juvenile who comes from speaks the language in our area, where I guess no one comes out to Northampton, where her interpreters aren't there, is going to get to withdraw their 15-year-old pleas because there's no one's memory is good enough and the dockets were inadequate. I'm not sure that's an appropriate solution in terms of the reality of what went on there. I suggest the juvenile defendant needed to come up with more, perhaps a court officer, perhaps affidavits from other practitioners. One of the cases, it's a Cologne, I won't cite the case where all the defective colloquies were shown in Springfield. There were affidavits from many other practitioners. There's no affidavit even from the trial lawyer here. If a solider showing, such as in that case, might be what's needed here. I don't think there was enough shown here that the judge was abused her discretion. But again, in terms of the facts of the case, I have nothing to add. Are there any further questions?
All right, thank you very much, sir.
You're welcome.
Justice of the Supreme Judicial Court, now sitting at Boston, within and for the Commonwealth. At present depart, give your attendance